Consideration of motion to dismiss the matters as moot filed by the Office of State Police in the matter of call Cavalier, docket numbers 21256D, 21257S, that is 21-257-S, and 21261-T. Are you here to present?
Good morning, Mr. Chairman. Good to see you again. Today, I'm Marshall on behalf of the Office of State Police, and I'm here to present on behalf of the Louisiana State Police our motion to dismiss this matter as moot. And also, I wanted to bring to your remembrance also we have Mr. David Messina, I think through that Zoom, who is the bankruptcy lawyer trustee, who is able to assist us in making sure that we have the receipt and release. And if the commission has any questions, he should be able to answer that concerning that matter. I would like to proceed to say that former trooper, Louisiana Trooper Cavalier, there were 3 disciplinary appeals in this matter. The first one is 21256D, 21257S, and 21261T. He filed a lawsuit in 19 JDC as against the Louisiana State Police, which was moved to the United States Middle District of Louisiana. On October 6, 2022, the Louisiana State Office, through the Office of the Risk Management, as well as the Attorney General Office, they mediated a settlement agreement, which was agreed by Mr. Cavalier, who was represented by counsel at that time by the name of Jim Kraft. The time of those settlements encompassed the resolution of all the disciplinary matters pending before this Honorable Commission. We expressed to you, he expressed his dissatisfaction with the terms of the settlement agreement. As a result, he wanted to continue the matter. There was a hearing before the United States Magistrate, Mr. Bourgeois. In Mr. Bourgeois' report, he recommended and rejected Mr. Cavalier's position. Also, this matter was heard by the United States District Judge by the name of John Dugraveau. These matters, we have briefed those matters to you with the exhibits which we have attached to our motions. And each one of these has been heard either by the district judge, and he appealed to the United States Court of Appeal in New Orleans. There was a lot of brief out. He represented himself, as a matter of fact, and the United States Court of Appeal affirmed the decision of Judge Dugraveau. He has 90 days from the time of the render of the opinion, which he did not do. So that opinion, as well as the mandate from the United States Court of Appeal, stands. During this proceeding, gentlemen, he also filed a bankruptcy proceeding, and that is where Mr. David Messina comes in.
About that, I don't really. I submitted the papers that were relevant to the bankruptcy court approval. Just to be clear, I did not represent Mr. Cavalier in the bankruptcy case. When he filed bankruptcy, there's a court-appointed trustee, Greta Brophy, who took over the administration of his bankruptcy estate. And what we had to do in order to consummate the settlement was we had to get bankruptcy court authority to do that. I submitted the papers. I guess the couple of things I'll highlight. We filed our approval motion. Mr. Cavalier did file a limited objection. The limited objection, though, did not go to the consummation of the settlement. Basically, his limited objection started out by saying the debtor, Mr. Cavalier, has no objection to the consummation of the mediated settlement agreement referenced in the trustee's motion. He had only objected to, he had 2 attorneys, and he didn't want the full contingency fee approved for the attorneys. When it came time for the hearing on the motion before the bankruptcy court, Mr. Cavalier's attorney did show up at the hearing, and he actually even withdrew the objection to the attorney's fees. So the bankruptcy court authorized the approval of the trustee consummating this settlement agreement with no objection whatsoever. And the last point I'll make is, and this is probably the most important part of the approval order, it says on the first page, the approval order ordered that the, quote, lawsuits and claims set forth in the receipt and release agreement between the trustee in the Louisiana Department of Public Safety and Corrections, Louisiana State Police, and Colonel Lamar A. Davis are property of the bankruptcy estate, and as such, the trustee has the sole right and exclusive authority to sign and enter into the release agreement and the dismissals described therein. So the bankruptcy court specifically found that this was the trustee's sole and exclusive right to dismiss these proceedings, and we've filed the appropriate motions to dismiss it.
Was there any ruling from the bankruptcy court or otherwise that you are aware of that spoke to the issue of this commission's authority over the appeals?
I'm not sure I understand. In terms of...
He has taken an appeal to this commission of the disciplinary action that was taken by the state police.
Yeah, you're talking about something separate from the appeals that went to the Fifth Circuit on the mediated settlement agreement?
Well, what went to the Fifth Circuit, as I understand, was whether or not the settlement agreement could be enforced. And we can read the settlement agreement and we will discuss our reading of the settlement agreement. I just want to make sure there wasn't a ruling from the bankruptcy court that had any statement relative to this body's jurisdiction over the appeals.
No, the only thing I would say is what the bankruptcy court approved was what was in that settlement agreement. That settlement agreement was attached to the motion. So I think you could look to the settlement agreement. If there's nothing contrary in that settlement agreement, I think that probably gives you the answer to your question.
I agree the settlement agreement gives us the answer. I just want to make sure if there were any rulings I was aware of what those were.
No discussion of that issue before the bankruptcy court.
Thank you, sir. Any other questions?
I think also I wanted to emphasize that the fact that they joined our motion to dismiss because based upon the settlement agreement, I don't think there's any jurisdiction pending before this commission because the matter has been resolved.
I understand. I'm not necessarily disagreeing. I just wanted to see if there was a ruling that I needed to be aware of.
Well, because I wanted to clarify that because when this matter started in 2022, there are new commissioners, and I wanted to make sure that that has been clarified because the ruling.
Do we have a copy of the agreement?
Yes.
Settlement agreement?
Yes. It's our exhibit 8 that I think exhibit 13 and as part of our motion. Okay?
Thank
so
you.
we really pray that this matter be declared to be moot and that these matters, all these pending claims, 2157S, 21256D, and 21-261T, before this commission be declared moot. Thank you.
It's good to see you.
Thank you. And by the way, this might be my last time seeing you guys, but it's been a pleasure to work with you.
Thanks for your service and the times that we've had the pleasure of working with you.
Thanks, sir.
Okay, in light of the fact that this matter involves allegations of misconduct, I entertain a motion to go into executive session to discuss those allegations and these related matters.
So moved.
Then moved and seconded. Take a roll call vote, please.
Chair Murphy,
Yes.
Mark Cole,
Yes.
Michael DeVos, Jim Kowalski,
Yes.
Martin Matalaga,
Yes.
Ross Bourgeois,
Yes.
and you Cindy.
Yes. Okay. For our previous executive sessions, we asked that everyone move from the room. Don't leave any personal items in the room. Then moved and seconded. Take a roll call vote, please.
Jerry Murphy,
Yes.
Mark Cole,
Yes.
Michael DeVos,
Yes.
Jim Kowalski,
Yes.
Martin Matalaga,
Yes.
Ross Bourgeois,
Yes.
and you Cindy.
Yes. Okay, at this point, we'll entertain a motion and any discussion on the pending consideration of the motion to dismiss.
At this time, I'd like to move to grant the motion to dismiss the matters as moved filed by the Office of State Police in the matters of call Cavalier. Docket numbers 21-256-D, 21-257-S, and 21-261-T.
It's been moved. Do we have a second?
I'll second.
It's been moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it, the matter is dismissed.